Bora Laskin was sort of a role model. He was one of the very first. He was one of the formative influences. He was someone I admired enormously. Jack Finkelman was the first of them, and he also was very helpful to me. In 1967, I succeeded Finkelman as chair of the garment industry. He had been chair, I think, since about 1935 or 36, and then had gone up to Ottawa to be chair of the new Public Service Staff Relations Board. I stayed in that position until the early 80s. We'd hold all our hearings at 5 o'clock, and nobody was ever late for dinner. Everything went very informally, and there were no lawyers. The parties would just contribute their version of the events. We'd have little discussion. We'd sort of agree on what the facts were, and then I'd make a decision.
They didn't change to any substantial extent in the garment industry, but in situations other than the garment industry, they did change appreciably. For one thing, lawyers got into the picture. There were no lawyers. I remember only one case in the garment industry where a lawyer appeared. Outside of the garment industry, though, it was not at all unusual to have both the union and the employer represented by a lawyer.
In about 1980, give or take, one of the large firms in the industry, Dilex, a vertically integrated firm, decided to break away from the whole style of arbitration, which was built very much on personal trust and knowledge and long experience of the parties. Decided to bring in a lawyer, and the lawyer decided to be a lawyer, to be very legalistic. I said I could get along very well without him. Parties had gotten on very well since about 1920 without a lawyer at all. My ruling was challenged and overturned in the courts. Ultimately, the lawyer did return. The hearing went on for days and weeks, and it really signaled effectively the end of the system.
I think what happened with Dilex was that this sort of power balance that existed started to shift, and the unions started to lose a little bit of power. And they brought in a much more formalized approach. They brought in lawyers, and they fought. They really fought.
I don't think it's necessary to have lawyers involved. I think it's necessary to have people who are experienced at arbitration. But I can think of a lot of people who are not lawyers and who do excellent jobs, both as arbitrators and as people presenting the case. I think it's important that people not be too legalistic in their approach to arbitration.
I think there should be less legal rules of procedure in an arbitration case. I think there has to be established procedures, but we have collective agreements where the arbitrator can establish its own procedure.
It's not so important to deal with legalisms. First of all, I think by using legalisms, you shut out a lot of the people for whom the award's written. The average person in management and union aren't lawyers, so if you start to use too many Latin terms, it's of no assistance to them whatsoever, and I think therefore you put it in common terms that everyone understands, and they can see why the decision went in this way.
I'll tell you, though, my concern at the present time with arbitration, the way it's going. There is a measuring of arbitrators that is going. As you know, the OFL has a list of every arbitrator in Ontario with a list of how that arbitrator has held on any one of 15 different issues. And they have, at certain times, blackballed arbitrators.
Well, I think blackball is perhaps a poor choice. Let me put it this way. Certain arbitrators are more acceptable than others. You know, what's sauce for the goose is sauce for the gander. The same thing is true on the employer side. I mean, I know, I'm not going to go into any names, but I know that there are certain arbitrators who are simply not acceptable to the employer side.
the result of that is a chilling effect on arbitration, because the arbitrators are very conscious of the fact that they have to be selected by both sides. When you put that type of pressure on, you defeat the whole purposes of arbitration and the independence of the arbitrator.
Well, the opinion of Mr. Heenan, I respect his opinion, but as Roy probably knows, I don't believe in that explanation. I don't believe that the neutrality of an arbitrator is compromised by this list on this chart. I think arbitrators feel comfortable with it. I think it helps the process. It doesn't mean that we win our cases.
True, but I just ran the report in the Excel format and just sorted it by days where the total was 0, and it comes out.
There's a reason why that list is there. We didn't just wake up in the morning and say we have to tell the arbiters how to decide in certain cases.
I imagine the reasons were very simply, very often trade unionists are called upon to decide whether they're going to agree or disagree to a particular arbitrator, and it was a way of organizing the information. Anybody can sit down and research how a particular arbitrator has decided a particular issue in the past. Arbitrators do have track records. All the chart does is organize public information in a manner which is accessible to trade unionists who have to decide whether or not they want a particular arbitrator in a particular case. I would have thought that Mr. Heenan would believe in the free flow of that kind of information. You know, with all due respect, employers do this all the time. Employer counsel do it all the time. They have the arbitrators they like and the arbitrators they don't like. And on particular issues, they have the arbitrators they like and the arbitrators they don't like.
But you believe that the parties should set the rules, or that an arbitrator should set the rules? My own view is that the parties set the rules. My concern is that there are two approaches to industrial relations. One which believes that both parties are reasonable, intelligent, and know the systems, and they will make their own rules. The other one is sort of a Superman approach to industrial relations. Come unto me, my children, and I'll tell you what's good for you. I don't believe in that. Where I disagree with Harry, and I think his point of view changed after the Port Arthur decision. I think that he was scandalized, I think would probably be the right word, by the decision of the Supreme Court.
Well, first of all, the Port Arthur shipbuilding case involved 3 employees who, during the annual manufacturing shutdown of the company, had been in the habit of going off to work somewhere else. As it happened on this particular occasion, they were called in to do some maintenance work. They weren't available because they had other commitments. And although the 3 of them had probably something amongst them like 60 years seniority, they were fired. I held that they had indeed an obligation to come to work when they were called in, but this was a vastly excessive penalty. I imposed a suspension instead. My decision was challenged. It went all the way to the Supreme Court of Canada, and the Supreme Court of Canada overturned my decision.
At the time, the law said that in a grievance arbitration where there was a penalty, the arbitrator only had a right to decide whether there was cause for the employer to impose a penalty. The arbitrator had no right to decide whether the punishment fitted the crime. Harry Arthur's changed a penalty from discharge to suspension with eventual reinstatement, and that's where he got into trouble. He was a brash young man who then became a highly respected figure, but I think he might do the same thing today. He did what he thought was right, and the heck with the consequences. The consequences were very important. The law was changed.
I think as arbitrators we were a little silly. We were running around like chickens with our heads cut off. I think the first thing that people did, what I did, I just said that unless the parties agreed I had the authority to modify a penalty, I wouldn't take the case. And of course, within a matter of no time, the legislation gave you that power.
It was as a result of that, however, that the jurisdictions, starting with the federal jurisdiction, the BC jurisdiction, the Ontario jurisdiction, eventually the Quebec jurisdiction, allowed arbitrators to substitute their own view. Now, the difficulty with that relates back to what I was talking about. I would ask you to define for me what penalties, what offenses merit a month's suspension as distinct from 3-month suspension as distinct from discharge. And I defy anybody to define those. You can't. There's a winner and a loser to an arbitration case. Once you try and modify everything and suspend everything or split the difference between the parties, there's a different administrative process.
There are some good things, but there are also some bad things about that theory. And one of the worst of those things is that it makes it very difficult for unions and companies and arbitrators and people on the shop floor to work out rules, dispute resolving mechanisms, and even fundamental legal values which work for them in their particular context, which make sense for them in their particular context.
I always say, if the arbitrator is going to split everything, I'll double. I'll suggest to my clients they double because it's going to be split anyway.
I think that does happen again when you have you tend to get bargaining situations, I guess, in grievance and arbitration cases where the union will, inflate their case to try to get, where you want to settle at. We'll inflate our numbers. I think employers are doing that too.
And that's not a responsible way of dealing with things. That's why I get worried when there is this tendency to split. If we believe in free collective bargaining, the arbitrators are there to apply the collective agreement, not to invent a new deal.
Well, that's part of his powers. The job of an arbitrator is to interpret and apply what the parties themselves have agreed to. An arbitrator can modify the penalty to a penalty which he considers more reasonable. One of the powers that an arbitrator is given by the Labor Relations Act is to determine his own procedures. And of course they have the power to make all the rulings that are necessary in the course of a hearing as a hearing is going on.
You would include then, I guess, someone who is on long-term disability of perhaps 2 or 3 years. They're absent.
Yeah.
Is that fair? With regards to the power of an arbitrator, most of our collective agreements is that we give the liberty, or we establish the power or the authority of the arbitrator in the collective agreement. An arbitrator can modify a disciplinary measure, can maintain a disciplinary measure, or establish all other circumstances or all other decision that he finds reasonable.
I used to use this story in class to indicate the way arbitration has changed and how you have to be a little bit careful about things. We had an employee at a rather large, sophisticated local factory. He'd been fired for a number of charges of insubordination, assaulting a foreman, and destruction of company property, all of which were proved. And he'd been dismissed by the company. I reinstated him with absolutely no loss and nothing on his record, even though all those have been proven. The circumstances were these. The man had been one of the best employees that the company had. He had won all kinds of prizes for being the best employee in this company, and he ran softball in the summer for little kids. You've never seen such a record. No disciplinary record with the employer. He was leaving work one evening, and a foreman called him over and said, "Look, I'm having some problems with a particular die. It's coming loose and it's stopping production. It's a very key point in the production system, and I want to get it fixed." So the fellow, being an obliging fellow, fixes it. He'd already clocked out, but he would do that sort of thing. He fixed it, and away he went. During the evening, somebody had messed around with the die, and it came loose in the afternoon shift, and of course all production was piled up and nobody could fix the thing. The next morning, in comes the grievor, and he's walking over to his job when he's hailed by this foreman. The foreman then said to him, "I want you to fix it the way you did it last night." The grievor said, "Well, look," he said, "somebody's going to mess around with it again. So if you give me half an hour, I can get this done so that you'll never have any problems again." foreman says, I insist that you do it. And so the griever says, well, look, I've got my own job to do. Foreman says, I don't care, you do that work. So he says, all right, I'll do it. And he begins to do the work. And the foreman leaves. Within a minute or so, up comes another foreman and says, I want to see you in the foreman's office. And the griever says, I can't go. I've been told to do this work. And I have to finish it. And it'll only take me a few minutes. And I'll go. The second foreman says, you've got to come. And he said, well, I just have to finish this. And he finished a minute and went with the other foreman into the foreman's office. When he got in, there was the first foreman standing saying, you made me essentially look bad in front of the other employees, and you were insubordinate. And I'm going to send you home for insubordination. And the second foreman said, well, and you were insubordinate to me, you wouldn't come when I told you to come. The fellow was very upset, as you can understand. He ripped a piece of paper that had some instructions on it. He hit the top of the desk and hit one of those little scoops that you take up. They're very light, they're tin, for taking nails. And the scoop went down and hit the foreman on his work shoe. They then said, we are fired because you assaulted the one foreman and you destroyed company property. They sent the fellow home. He went out to a place where they had the lockers, and he just broke down. I always thought that was one of the worst cases I ever saw of sort of pettiness and the effects it could have. And I quite destroyed this fellow. Remember the fellow presenting for the company asked me how long it was going to take to get my award out, and I just said no time at all and reinstated him on the spot.
I feel that an arbitrator should be free to conduct the process that he wants, because an arbitration hearing is not a show. The arbitrator is there to give the interpretation to a collective agreement.
One very interesting experience I had in the North was pioneering community health clinic. One day a receptionist at the clinic got in an argument with the supervisor and cursed rather loudly while there were some patients around, and was fired. I wrote an apology and the receptionist signed it, and she gave it to her supervisor. The griever was a little tiny sparrow-like woman, I remember, and the supervisor was a great big woman, and the supervisor took her and pressed her to her ample bosom, and they kissed, and it was the most successful arbitration I had ever conducted.
That's a paternalistic way of looking at it. They're much wiser than the parties. That's not good, because it doesn't encourage responsible administration by the parties.
Well, you just can't walk in with a system of arbitration and say, here's a brand new system. It has to grow out of a relationship. It has essentially to be developed by the parties. The arbitrator can help them, can respond to them, can be faithful to their wishes. But if the parties don't wish it, it isn't going to happen. So a highly informal, expeditious system depends on the desire of the parties to have such a system.
An arbitrator's role is not to impose his or her own brand of industrial justice, but to apply the rules which the parties have made in their collective agreement.
There has to be some rules and some guidelines, yes. But collective agreement is a guideline of how working conditions are going to be, et cetera, et cetera. If an employer wants to violate those guidelines, then the grievance arbitration procedure comes in. So arbitration has to be, in my book, has to be a flexible process, and it's a way to arrive to a solution. It's not a civil court, or it's not a criminal court, because the grievance to arbitration process is, you have to understand the aspect that it is human relation and humans that we're dealing with.
I mean, I think there's a tendency of lawyers to speak to lawyers in the courts and so on. But when you're dealing with an arbitration, the case has a function of an ongoing nature. These people aren't just going to disappear and never see each other again, like in a traffic accident. So you want to give them that kind of award, and lawyers have to understand that. Some don't.
Informal versus formal, which do I prefer? I guess I feel that an informal way of resolving grievances is a constructive thing. If, having said that, once a company goes a very legal route and is, treating it in a more formal manner, then the union really has to respond in kind. Otherwise, we're at a big disadvantage and we risk losing at an arbitration hearing. We're operating in a very anti-union environment right now. Unions are having to fight back a lot more. In terms of workplace actions, we're showing the employer power in different ways to achieve the goals that we want to have, which is, a workplace where workers are respected and have a voice in the workplace. And I don't think that's a lot to ask, but some employers fight that a lot.